My name's Penny Howe. I'm a specialist children lawyer in our team, which consists of many from top to bottom in chambers. And Jennifer Swan is one of my very best junior colleagues. So let's get the ball rolling, if we may. Although the talk was advertised as one about H&N, I'm afraid I decided to shamelessly hijack it to talk to you a little bit about the Domestic Abuse Act. And the reason I chose to do so is because, well, firstly, it received its royal assent after much toing and froing on the 29th of April of this year. And secondly, because it will bring with it some implications for the way that we practice. It's got some provisions in it which will directly impact the way we handle domestic abuse cases. And so although some of the implementation dates are unclear, it's good to know what's coming down the tracks. And then I'll hand over to Jennifer, who will talk to you all about HN, what it means for us going forward, and the changes we might see in the way cases are managed and handled at court. So I'm going to bring up some slides and I hope these will work seamlessly. Oh, good, that's a good start. Title slide, and then we move into the material for our talk. As I say, Domestic Abuse Act, it's big news, just passed into law, but the implementation timetable remains quite unclear. There's lots in the Act, it's going to be a big study, but the headlines I wanted to talk to you about were the new statutory definition of domestic abuse, the provisions that relate directly to protection for victims and witnesses. Now, by that I mean changes that will be coming in relation to special measures.
Penny, sorry to interrupt. The slides aren't visible to the audience. I don't think you've clicked on screen share. I'm monitoring the chat function.
Oh, well, that is not good news. Let me just escape from where I am and see if I can rectify that. Bear with me. I think we're going to solve it here. And let's try that. That's better. I can see myself now. I did wonder what was going on. Anyway, here's the slide I was just speaking to, and it relates to the headlines that I wanted to talk to you about. New definition of domestic abuse, provisions about special measures, amendments to section 9114 of the Children Act, and the introduction of domestic abuse protection orders. So let's look at those in turn. And first, the new definition of domestic abuse. And I've highlighted for you the part that stands out and ties in with our talk about HN, which of course is the inclusion of controlling and coercive behaviour, spelling it out as one of the varieties of domestic abuse that is relevant. Interestingly, at the bottom, you'll see that the definition includes a clause that domestic abuse encompasses these behaviours, whether as a single incident or a course of conduct. Sits a little bit oddly with the inclusion of controlling and coercive behaviour inside that definition, just because, as we know, what we're really looking for there are patterns of behaviour. But there we are, that's the new definition. The next part of the definition that's worth talking about is that the Act provides that abuse is carried out by a person over 16 towards another person over 16. And the government was very explicit that this Act was designed to cover acts between adults or near adults and not abuse towards children, which should be dealt with under the existing provisions of the law. Connected persons, as you can see, are defined and need not be in the same household. Well, that makes a good deal of sense. Interestingly, I think the definition also encompasses behaviour that A shows towards B, despite the fact that it's directed at C, and that might be a child of the household. So that's a really interesting provision, I think. because there we're looking at not just the impact that domestic abuse has on children who witness it, but also at the ways in which children are, if you like, recruited to abuse, are used as a means to abuse, harass, emotionally abuse and undermine another person who is relevant. So I think that's one to watch and one to think about going forward. Now, moving on then to the issue of special measures. There's going to be changes coming down the tracks to FPR3 and the relevant practice direction. Not big changes, but nonetheless important changes, because where a person is or is at risk of being a victim of domestic abuse, carried out, as you'll see, by a range of relevant persons, it is to be assumed that the quality of their evidence will be diminished and that they need assistance to participate. So instead of jumping through the hoop of having to demonstrate vulnerability, that will be an assumption as a starting point. It doesn't mean that you'll get any particular special measure as a guarantee. It simply puts you at the starting point of consideration by the court as to what, if any, special measures are necessary and ought to be implemented. But you'll see that it relieves a burden that used to exist to try to demonstrate vulnerability. Then we move swiftly to the section 65 of the Act, which is going to implement a scheme of amendments to the Matrimonial and Family Proceedings Act. And this is intended to address a long-standing point of debate, discussion, disapprobation, which relates to the cross-examination of victims by their perpetrators. And indeed, the other way around, the requirement for victims to cross-examine their perpetrators in certain circumstances. There is going to be an automatic ban on that in certain circumstances. And you'll see there I've bullet pointed the where that will apply. There's much that remains to be defined. So, for example, at bullet point number 1, you'll see where one party has been convicted of, cautioned for, or charged with certain offences, their cross-examination of the victim will be prohibited. What those offences will be, we don't know yet. It awaits statutory definition, and we'll see what it encompasses. And then in the third bullet point, there's quite a complex provision, I think, about where there is other evidence of domestic abuse perpetrated by a party towards a witness or indeed another party. That sort of evidence will be specified in regulations, and we haven't got those yet. Although you'll see the government has suggested that they intend to replicate the evidence criteria used in the legal aid regime. Now, you all, I suspect, know a lot more about that than I do, but you'll see that there is going to be a sort of a way of analysing whether the prohibition is relevant. Quite what happens to move from A to B, how you're going to demonstrate to the court that there should be an automatic ban of cross-examination remains to be seen, I think, but we'll see what the government's intention was and how it's to be implemented and move forward, I think will be interesting to follow. There will also be a discretionary prohibition, which exists for the court's discretion. It will be an analysis as to whether the quality of the evidence is likely to diminish if cross-examination is conducted by A, or is likely to be improved if A is prohibited from so doing, or the cross-examination by A would be likely to cause significant distress to a witness or party B, more than if it were conducted in another way. There will be a checklist of considerations for the judge, and importantly, a direction may only be made if it's not contrary to the interests of justice. So again, much remains to be shaken out here, but it's worth bearing in mind as we move forward to watch out for this introduction coming down the tracks. What will happen instead if party A is prohibited from cross-examination? Well, in current circumstances, we already know that judges sometimes take over the role of testing evidence, and that will remain open. And then there will be a scheme whereby the judge will try hard to identify a satisfactory alternative to cross-examining in another way or obtaining the relevant evidence. If that's not possible, the court must then invite the prohibited party to arrange a qualified legal representative to cross-examine. If they don't, the court must then consider whether it's necessary to appoint a qualified legal representative purely for the task of cross-examination, not to represent that party's interests, brought in specifically for the task and paid out of central funds. Now, I think loads of questions arise here. What sort of delays are going to be caused by this requirement to try to require someone to appoint a legal representative? What sort of delays will be imposed by appointing a legal representative? Who is going to want to take on that task? Who is going to feel it matches with their overall scheme of work and professional duties? I find it quite complex to understand how it's going to work in practice, but it exists, it's going to be brought in, and there will be much to, I think, discover as we move forward. Now, Section 67 of the Domestic Abuse Act will amend Section 9114 of the Children Act, that well-known provision, again quite a vexed one, about requiring applications in the future to go through a stage of obtaining leave. And the introduction that Section 67 will make is that a 9114 order can be made where a court is satisfied that the making of an application would put the child or another relevant individual, i.e. a victim of domestic abuse, at risk of harm. And that will be a provision that the court will be able to consider and make of its own motion. And then there will be the introduction of a requirement that where an order is in force on any application for leave, the court must consider whether there has been a material change of circumstances since the order was made. Now, I'm only really able here to convey to you the bare bones of the changes coming. How this will be interpreted, I think, is a completely different issue. It's one we're going to have to watch, but I think it's good to know that that's coming and will broaden the scope of Section 9114 in my view, and will probably help in bringing some clarity as to what the court should be looking for when dealing with a Section 9114, an application in the teeth of such an order for leave to apply again. Now, we're nearly there with my part, but I want just to tell you about domestic abuse protection orders, which will be introduced by the Act. Again, implementation is not clear yet. We don't know when these are going to come in. We're told by the government they hope to implement either this year or next, but we'll see. These orders will replace domestic violence protection orders. They will be similar in many ways because police will be able to issue domestic abuse notices. They'll be able to take cases to the magistrate's court without the victim taking the lead. So they will continue to provide the important measure of the police taking matters forward without the victim having to take the lead. But domestic abuse protection orders will also be available to the family court judge, either on an application or of its own motion. And they're intended to sit alongside but not replace non-molestation orders under the Family Law Act. My slides are really far too brief to be able to do justice to the topic, because I think there's a lot of unknowns at present as to how those two sorts of order will sit together, which will be intended to have primacy, how the choice will be made between going for one order or another. Again, all I can tell you is that a lot remains to be worked out, but there we are. There's new orders coming in that will be available to us in our courts, and I'm sure will form a very important backbone of practice in domestic abuse as we go forward. So watch out for more. Finally, from me, just to move us more in the direction of what Jennifer will be talking about, I've included a slide about what controlling and coercive behaviour is. And I'm going to bring you back to Section 76 of the Serious Crime Act of 2015, which brought in the new criminal offence of coercive and controlling behaviour, with a maximum sentence in the Crown Court of 5 years of imprisonment. And there's some interesting and I think important statutory guidance under Section 77 of that Act, which discusses and introduces information about species of coercive and controlling behaviour. I've put up a link because it's interesting to read it. And at page 4 of the guidance, there's a table of kinds of behaviour that might fall under the definition of coercive and controlling behaviour. Probably none of those will be unique to you, but it's a nice encapsulation of what to look out for, ranging all the way from physical abuse to the sorts of controlling behaviours that undermine another person, all sorts from financial to emotional to physical, and of course all working together in a pattern to form a particularly insidious, difficult, pervasive form of abuse, and one that rightly now has come to the fore for attention. So I commend that guidance to you for a read when you have a spare moment. And I'm now going to hand over to my colleague Jen, who will talk to you about HN and all the implications it has for us. Let me just take a moment to stop sharing my screen, and we should be back with you ready for handover. Thank you very much for listening to my part of the talk.
Hi everyone, I hope you can hear me. Thank you so much, Penny. I'm sure everyone agree there was loads to think about in that talk. And now I am going to try to share my screen so we can move seamlessly, into my part of the talk. And predictably, I am not on the first one. Here we are. Yes, hello everyone. Thank you so much for joining us this afternoon. We realise that we're eating into your Friday bank holiday lunch hour. I will be looking at the relatively recent Court of Appeal decision, re HN and others, and looking at hopefully the most salient parts of the judgment and thinking about what exciting changes we can perhaps be looking forward to as a result of the judgment, and thinking about what we can be doing now as practitioners to best serve our clients, whether you're acting for the alleged victim or the alleged perpetrator. And I should say as well that about a month ago, myself and Penny were hosted by Mark Ablett on the Pump Court Family Law podcast. And we discussed this topic, and we were also joined by Shona Dillon from Aurora New Dawn, which is a domestic abuse charity based in Hampshire. I have been told that I am to plug both the podcast in general and that episode in particular, so please do give it a listen if you want a more sort of informal talk and discussion on this topic. But anyway, what I've done first is I have given you some sort of headlines that I'm going to be focusing on, these takeaway points. If you remember nothing else, as I've said. So what we can take away from this judgment is that we now have a proper approach for deciding whether or not there should be a fact-finding hearing, the steps the court has to take. Secondly, sadly, Scottish schedules are on the way out, RIP, although we don't know what's going to replace them yet, so that's something exciting for us all to look forward to. Thirdly, controlling and or coercive behaviour will now be the focus in cases where there is a fact-finding hearing and it's alleged. So that's a really huge, excuse me, that's a really huge change, and obviously really interesting considerations and discussions about how we best do that within the sort of remit and within the constraints of the system we're all operating in. And lastly, keep your criminal law out of our family jurisdiction. There is no place, say the Court of Appeal, for criminal law concepts in the family courts. What matters in a fact-finding hearing are the findings of fact. So they're my most important points. So, hopefully you won't go to sleep, but if you do, then you don't really miss a lot. So moving on, for everyone who has stayed with me, moving on to the case itself, it was 4 appeals in private law cases, which were all heard together, and they all involved allegations of domestic abuse made within those proceedings. And what the court made a point of highlighting is that this is really, these are far from unusual. The family courts, they estimated, deal with about 22,000 cases involving domestic abuse allegations per year, just within the Children Act, the private law sphere, so not counting any standalone Family Law Act applications. So really this goes to sort of the heart, the day-to-day functioning of family justice. All but one of the appeals was allowed. The one that was refused was academic, but none of the decisions themselves established new law. So I'm not going to go into detail about the facts. We don't have time for one thing, but the bit that we are interested in as family law practitioners is the general guidance that the court gave about the issues that they said of great importance to everybody and things which frequently come up. And they're on the screen in front of you now, I hope. They should, and they follow, unsurprisingly, my takeaway points for the talk. So what they considered was, what the proper approach should be when deciding whether there should be a fact-finding hearing. They discussed the challenges presented by Scottish schedules as a means of pleading a case. If a fact-finding hearing is necessary, they asked how should allegations of domestic abuse be approached, and as I outlined previously, the relevance of criminal law concepts. And there is a limit to the guidance. The Court of Appeal quite properly said that there's only so far they could go. There are other agencies, other bodies looking at this area as well, including, of course, the Domestic Abuse Act, which you have already heard about. So let's look first at what the Court of Appeal said we should be thinking about when deciding whether we need a fact-finding hearing. And what I've done, they considered Practice Direction 12J, the sort of key tool for the court when considering allegations of domestic abuse and how to approach cases in which that's a feature. It is fit for purpose. Everyone's very happy with PD 12J. They also considered the road ahead, the President's guidance, and the overriding objective. And what the court did in a neat paragraph 37, it's up on your screens. They outlined the steps that the court needs to take. So when you're arguing one way or another, whether you need a fact-finding hearing, they've given you quite a neat paragraph for your skeleton arguments. So we have a new, nice, neat and tidy test. It's not new. We have a new amalgamation of a neat and tidy test. But looking at it from a practitioner perspective, what you focus on is obviously going to depend which side of the coin you are arguing on any particular day. You know, excuse me, are you representing the alleged victim, you know, the client who's facing the prospect of sending their children to stay with an unsafe parent? What are you going to be focusing on? I would be looking at the definitions of domestic abuse in Practice Direction 12J, and they echo what Penny's already said about the Domestic Abuse Act. It's the act or pattern of acts. If you're concerned about coercive and controlling behaviour, or even just domestic abuse in general, the court made it very clear that the court should be considering the wider picture and looking at a pattern of abusive behaviour. Similarly, the recent High Court decision of F and M, and I've put the citation on the screen as well, that was described as required reading for the family judiciary, and it involves a really, really serious case of coercive and controlling behaviour, really terrifying, frankly. And it was commended in the ReHN, and the quote, which I think is one of the most important, is that, you know, we need to be thinking about the impact of cumulative behaviour rather than isolated incidents. So again, if you're saying there definitely needs to be a fact-finding hearing, this is what you're focusing on. And when you're looking at necessity, because the court were very clear that necessity is key, fact-finding hearing has to be necessary. The Court of Appeal in this judgment outlined the potential impact on children who witness coercive and controlling behaviour and how harmful it can be. So really, by focusing on that, you're drawing together the impact and why it's necessary, and you know, that's on your screen. I'm not going to read it to you, but what I would say about number 4 in that list is I don't know why it says that this is particularly so in boys. I don't know whether there was a particular piece of research that the Court of Appeal's attention was drawn to, but it does seem to me that it's no less unsafe for girls to be exposed to that sort of corrosive relationship dynamic. So you know, I may well be missing something, but I don't think it's just limited to boys. So that's if you're arguing for a fact-finding hearing. But what about the other side of the coin? You know, you're representing the alleged perpetrator who's potentially facing months of not spending time with their child or children, even if the allegations are not found proved. So what are you focusing on in that circumstance? You know, I would be focusing on, the Court of Appeal were very clear, not every case requires a fact-finding hearing, even where the domestic abuse is alleged. Not all directive, assertive, stubborn or selfish behaviour will be abuse. It's about, you need to look at the intention and you need to look at the impact, but I think that's quite a neat little quote. And they also commended the ReL case, which again, the citation is on your screen. In some cases, it will not be in the interest of the child or of justice for the court to allow itself to become another battleground for adult conflict. And I think that as practitioners, we have all been there when one parent or another just wants to be heard. Frankly, they're angry about the end of the relationship, and they want to be heard. And you know, there is a balance to be struck, and you need to focus on necessity. And the court, as I said before, was very, very clear that then, you know, a fact-finding hearing needs to be really necessary, as this isn't a freestanding jurisdiction for airing allegations of domestic abuse. And there is a tension, and we discussed this in quite a lot of detail on the podcast. And since we recorded the podcast, I've done a couple of cases involving allegations of coercive and controlling behaviour. And the way that I have dealt with it on a couple of occasions is where you're in the situation where you might need a fact-finding hearing. They're not absolutely clear-cut allegations, we're unsure, is I have asked the court to order evidence from the person making the allegations and responses from the alleged perpetrator, and then list another directions hearing to have a meaningful argument, effectively, about whether or not a fact-finding hearing is necessary. And I recognise that there are obviously downsides to that way forward. I'm not sort of saying that this is a brilliant solution, but it does seem to me that if you aren't clear, then knowing exactly what the allegations are means that you can have a much more meaningful argument about whether or not you need this fact-finding hearing, although I recognise that there are cost implications, time implications. It's something that I have found useful on a couple of occasions. Looking forward to what exciting changes we can potentially look forward to, CAFCAS, on behalf of CAFCAS, the submission which was on your screen was made. Essentially, CAFCAS suggesting that prior to the decision about a fact-finding hearing being made, the court could think about having some CAFCAS involvement akin to a social work assessment, perhaps seeing the child, and perhaps that could help focus people's minds. We did discuss this on the podcast as well, and I have to admit that I was quite in favour of it, but as everybody else pointed out, it would need to be properly funded and given a sort of proper remit. And I'm sure, I don't know whether there's anyone from CAFCAS here today, probably not, but I'm sure they wouldn't mind me saying that they are already, as an organisation, very overworked, very underfunded, and there is a real potential for delay if it's not adequately resourced and this idea comes to fruition. And it's what will be at the forefront of your mind as a practitioner if you're representing the alleged perpetrator is, of course, that they will often not be having any contact with their child or children, and that's a real headache for practitioners in my experience. And it's noticeable that the Court of Appeal in this judgment doesn't deal with the questions of interim contact and that sort of really difficult question. And it may be that we can look forward to some more guidance, some more appellate guidance. But it's, there is a real tension, and everyone who works in this jurisdiction will be familiar with those difficulties. Moving forward to look at the second area, which is Scottish schedules, RIP. There was apparent unanimity in submitting that Scottish schedules were unhelpful. I do love a Scottish schedule, I confess, but that's by the by, I'll come to terms with it. The Court of Appeal was very clear that we need to be moving away from Scottish schedules, and of course they do have their origins outside of the family jurisdiction, so perhaps that is right. But then what do we do instead of a Scottish schedule? And there were 3 suggestions that were made in submissions which the Court of Appeal mentioned in their judgment. So they said we could have a threshold type document, as you commonly see, or as you almost always see in care proceedings. Do you have formal pleadings by way of a particulars of claim, as you would see in civil proceedings, or do you have a narrative statement in a prescribed format? And the Court of Appeal were very clear they're not giving a view on this. It is somebody else's problem, and I think as family practitioners, this is something that's going to impact really significantly, both on the way that we plead a case, obviously, and then on how we run a case at a fact-finding hearing. For what it is worth, I think that I am most attracted to the idea of a threshold type document. It's probably because I do a lot of care. In those documents, it is quite common to have a sort of headline fact and then sub-facts to prove the headline fact. For example, when we're dealing with things like chronic neglect, it is very common and it works relatively well. I have to say that the idea of a narrative statement fills me with horror. Although it was pointed out in submissions that a narrative statement does have the benefit that it can focus on the impact of the behaviour on the alleged victim. And of course, the Court of Appeal drew that important link, the impact of the behaviour. But I have to say that in my view, a well-drafted threshold will do that anyway, because of course you have to link the harm or the behaviour, to the harm caused to the child. So I don't see that as an insurmountable problem. But anyway, we don't know what's going to happen. So very exciting, watch this space. But you will have seen the problem sort of coming down the tracks like an express train. Because when you start to piece these things together from a practical perspective, you're asking us to focus on cumulative behaviour, saying how important it is. Secondly, you're saying, well, you can't have your Scotch schedules anymore, these sort of handy compartmentalised tables, you've got to do it differently. So all of these things together start looking like they're going to be starting to make things much, much more lengthy and much, much more complicated. So just you wait. So the next thing the Court of Appeal looked at was the approach that should be taken to allegations of domestic abuse, in particular coercive and controlling behaviour. And what I've done is I've quoted the relevant paragraphs on the slides. It was submitted by the representative for the second intervener, which were the Women's Aid and other women's groups, that the overwhelming majority of domestic abuse is underpinned effectively by coercive and controlling behaviour. And Shona Dillon from Aurora New Dawn on our podcast said the same thing, and she said basically everyone who works in domestic abuse already knew all of this, and we're really late to the party. She called it the invisible noose, that hangs around the neck of the victim at all times, and that's quite a sort of graphic but useful analogy. And what the Court of Appeal said, that this is likely to be the key issue, or this will be the key issue. It's not going to be acceptable any longer to just think, well, this is in the past, it's not relevant anymore, it's old-fashioned. And if a judge does not consider allegations of domestic abuse, then they are likely to be appealed effectively. So the result being that where there are allegations of a pattern of coercive or controlling behaviour and a fact-finding hearing is necessary, then that allegation should be the primary issue for determination. And what they said is more specific factual allegations that we're perhaps more used to dealing with as practitioners should be selected for determination to prove the pattern, unless, they say, unless a factual allegation is so serious that it would require determination completely outside of any pattern of coercive and controlling behaviour. And the example that they gave was an allegation, excuse me, of rape. So again, that's a huge shift in focus, because we will all know that when you're putting together your Scotch schedules, then you focus on the allegations of physical and sexual abuse mostly, because you're able to be specific about them, because they are much easier because of the specific nature of them to prove. So it's a really significant shift, this judgment. I'm sure that we will all agree. But when you're combining this with your focus on cumulative behaviour and you're doing away with Scotch schedules, it is not difficult to see, as I've already alluded to, the potential really significant problem with resources and timescales. However much the focus is on necessity, the Court of Appeal do seem to have sort of, at first blush perhaps, said that unless this pattern of behaviour is admitted, or unless you have an agreement in respect of contact, which is what happened in one of the appeals, then you're almost compelled to have a fact-finding hearing, which of course is going to have really serious ramifications. And it will be interesting to see how this decision filters down to sort of your magistrates and district judges' courtrooms up and down the country, and what the impact on the ground is going to be. But importantly for us at this stage, as practitioners, what do we do when you are dealing with the alleged victim in particular, because that's when you've got to really start thinking about identifying and pleading your case. What do we do? And early identification, if this is going to be an issue, is going to be absolutely key. You need to be sort of flagging it with the court as soon as possible. And one of the things I'm going to shamelessly repeat what Shona Dillon said on our podcast, it's not mine, when she gave us some really helpful pointers for getting information and sort of starting the conversations with alleged victims. And one of the things that she suggested starting with was simply by asking your client, are you afraid? Are you afraid of the other parent? And getting a narrative from them. And that's something that the Court of Appeal said that one of the suggestions they made as well. Can you get a narrative overview from your clients about their experiences of being in a relationship with the other person? And that's likely to be very helpful in sort of getting a more general sense of the character of the relationship. One of the things that you can use, she recommended for having those discussions and trying to distill down the allegations, is the power and control wheel, which will be familiar to a lot of you. It's quite often used in things like CAFCAS reports, social services assessment, things like that, but you can just Google it, and it's a visual aid. And she recommended that. And she also encouraged us to think about what alternative sources you can get information from. So things like if your client has been to a refuge, if they've been to a GP, if they've been to a hospital, you don't need a court order to get that information. And it may ease some of the burden on your client of repeating everything and enable you as a practitioner to get a fuller picture of their experiences. And I do realise that all of this depends on you being instructed in very good time and having loads of time to prepare, and I'm not being naive, but things to think about. And how do you plead the case? And that's going to be really tricky, because until we're told what to replace Scotch schedules with, that's what we've got. But what I would be doing is highlighting it with the court as soon as possible, and that is what I did in cases that I've been involved in. You have to really flag it for them that this is what they're going to be dealing with potentially. In terms of the number of allegations, obviously this will depend on the court, but I think that the days of being forced to or being told to trim your allegations down, to 6 to 3 and then to 2, those days are gone. The court have made that very clear, that this cumulative effect is very important, so sort of stand your ground on that one. When you're looking at the narrative statement that's prepared, focusing on the impact of the alleged behaviour, I think will be really crucial and really helpful, because of course, as I outlined earlier, the Court of Appeal there needs to be this causative link, that it's the impact of the behaviour is going to be something that is crucial. And also, we don't have to abandon our, the allegations that we are more used to seeing. There's still a real forensic importance to allegations of physical and sexual abuse in particular. And it may just be that you say to the court, well, the coercive and controlling behaviour provides a context, and context is everything. So don't be afraid, basically, to continue to rely on those. But I do acknowledge that these are just sort of my thoughts from various sources, and this is a huge, this is a known unknown now. We know that we don't know what's going to be happening in the future. I'm very aware that I am running slightly over time, so I'm going to deal with the criminal law concept at a bit of a trot. I can deal with it very briefly, in fact. No, don't do it. We don't like it, said the Court of Appeal. It's fundamentally wrong. And what they're talking, when they say criminal law concepts, they're talking about things like, don't let your judge get bogged down in, whether someone's actions constituted self-defense or whether it was ABH or GBH. It's unhelpful. What matters is a narrative finding of fact. That's what we're dealing with. So don't let your tribunal get distracted, but at the same time, don't be afraid to call a spade. Rape is rape, and to avoid criminal concepts that are sort of common in everyday language, they said would basically be nonsensical. So don't take it to extremes, basically. And I think, yes, I've come on to my final slide, and finally, I'm just bringing you back to the beginning. And with a bit more context, I hope that everyone has found that useful. And yes, I'm only slightly over, so I do apologise about that. I will stop my screen share now, and she says confidently, and hopefully we can go back to the full team. Do we have any questions? I don't know how you want to deal with this, Penny. Oh, I've seen you put a note. You're on mute.
As always. We have an excellent question from Tasha Bevan-Stewart. Tasha, thank you very much. It asks, or it tells us, in fact, Tasha's already seeing coercive and controlling behaviour being raised in cases where there really isn't any. It seems solicitors will use it, and a perception that it is trendy to allege. How do we guard against the allegation being raised in every case of an acrimonious relationship breakdown? And how do you respond to an allegation which is clearly not accurate in correspondence? I think that's a massively tricky one. Don't have brilliant answers for you, but I've been thinking about it as we've gone along. I think it chimes in with what Jenny has been talking about. I think we are at risk of an avalanche of applications being made to the court now under the headline of controlling coercive behaviour. How can we not, in the teeth of this decision from the Court of Appeal? We're encouraged to look for it now. What would I do if I got correspondence alleging it? I suppose I would go back to the old-fashioned way of requiring particularisation. We know that that's dangerous because it draws out, it potentially draws out the allegations, it draws out the what underlies the acrimonious nature of things, but I'm not sure how one can tackle it really. If it's going to be alleged, you need to know exactly what it is the person is alleging you said or done. And don't forget that the Court of Appeal has at least allowed us the fact that not all stubborn, unpleasant behaviour in the context of a breakdown amounts to abuse that's relevant to be decided in the court. But the broader answer to what you raise is, I'm not sure that we are able now to avoid a scenario where we're going to end up with far more cases coming to court, far more attempts to prove that there has been coercive and controlling behaviour. Loads, I'm afraid, of litigants in person on the other side responding to those allegations, and the court's resources being tasked to the extreme, firstly in the task of trying to resolve which cases need a fact find, secondly then in the task of undertaking those fact-finding exercises in circumstances where in the end it's going to resolve down to the judge hearing oral evidence by and large from two individuals with different stories to tell and arriving at a view based on credibility and feel. How one short circuits all of that, I have no idea. So I'm sorry, if anybody on the participant list has anything else to offer or comes up with solutions that we can't foresee, please would you let us know, because I'd be fascinated to hear. And we've got a little bit of time for that if anybody would like. I think we're in the teeth of such fundamental changes that none of us have the answers until we've travelled the path for some distance and we know how the court will get a grip on this. And at some point, I'm confident things will go back to the Court of Appeal, potentially for them to say to us, you know, when we suggested that fact findings were necessary in so many of these cases, well, perhaps we need another look at that and find a different way through. So anyway, thank you for the question. Perhaps next year we can provide you with a seminar that offers more pertinent answers, but I think we are following the path as closely as you are. Other questions we now have, and I'm going to ask Jen if she'd like to deal with this one from Chris.
No, Chris has given us an answer. It's a great answer.
Oh, fantastic.
Thank you, Chris. And yes, to address the delay issue, court needs to consider these issues as a gatekeeping stage. And I would agree that's a super idea. And it comes back to what you were saying, Penny, about needing particularization. If by the FHDRA you need to, you need to have set out your stall effectively. If you're alleging coercive and controlling behaviour, then that can really help the arguments that you're having about whether or not a fact-finding hearing is necessary, rather than doing what I had to do in my couple of cases, which is say, oh well, I'm afraid we need to see what's being said before we make the decision. So I think that is excellent, and if those allegations are likely to be raised, then it may be that practitioners can write to the court and say this needs to be dealt with as a matter of urgency.
I agree, and I think that feeds back into this idea of requiring particularization early on. You want to know what it is you're being alleged, how significant is it, what are you dealing with, and that feeds through to, as Chris says, the very earliest stage of the court process, where that sort of triage and filtering is going to be absolutely vital. So good idea, Chris, I agree, as does Jen. I think that would be important. Tim, do you feel that the issue of did any of this happen after you allowed unsupervised contact is still crucial? Yes, I think it will be important, but that perhaps risks in some ways missing the point that the pervasive nature of controlling and coercive behaviour is highly likely to continue to impact moving forward. I agree, one would want to know what are the particulars of what this person has done post-separation, but I think it's not going to be by any means the complete answer to the relevance of a decision by the court as to whether the relationship has entailed this sort of abuse. So half yes, definitely a question to be asked, but not the whole answer. And then we've got a comment, I think, on our chat. This one comes from Laura. It says, essentially, that's where the C1A comes into its own. But if we are moving away from schedules, then perhaps the C1A is redundant. That's a really interesting one. I think the C1A will still be essential for flagging what's alleged. It's, as you point out, it's going to be crucial that allegations of coercive and controlling behaviour are made out. I don't think the C1A will be redundant from that perspective, but there is going to have to be a focus on separate particularizing of the allegation. In other words, making out the headline allegation as the proceedings progress, and how one utilises the C1A to start doing that, I'm not sure, but perhaps it will retain a function in that regard. Are there any other questions or comments or feedback that you'd like to give us now? We're very open, although we know time is pressing, and I dare say on a Friday you have other things to do. Do let us know. One from Callie, a comment. One way to resist unfounded allegations could be to show that there is no power imbalance. Agreed. Agreed. An interesting one though as to how one goes about that. I'm interested to think about that and how one could establish that at first blush. And one from Helen, who is one of our colleagues. Helen, thank you for joining us. Present in a public law fact-finding hearing where the judge directed cross allegations to be set out in schedules. One complied, one didn't. Okay, so again, I think that is about particularization, getting in there, particularizing what you want to demonstrate to the court, and moving forward. Perhaps that's our underlying message then, to get to grips early and make sure that the issue is in focus and in view crucially at the earliest possible stage. Another from Sarah, there's been a message saying, just to say that I anticipate numerous cases where the mother alleges coercive and controlling behaviour and the father alleges the mother is carrying out child alienation. I'm sure you're right. I'm absolutely sure you're right, Sarah. We're sitting, I think we all agree, on some sort of kind of litigation time bomb, really. The focus is right. It's right that we recognise this kind of abusive behaviour and the role it plays. But from the perspective of what it means for us all as practitioners, the increase in workload and, more importantly, the requirement for court resource, I think, is what worries us all hugely. And the delay, obviously, huge delays that will likely be entailed, not good for children, but that's where we seem to be heading. All right.
I should say that there have been a few questions about slides, and my understanding is that they will be emailed out to people. And our marketing manager will be dealing with that jiggery-pokery.
Absolutely. Well, thank you very much. We've really enjoyed talking to you today. One final one from Michelle. We don't want to leave this out. Local magistrates often want us to limit our number of allegations in schedules. Can we now argue that there should be no limit? Absolutely, you can. Waive the judgment in front of them if need be. There's going to have to be some kind of containment. And I suspect what will happen is that we will all get used to the sort of drafting that Jen has talked about, the headline of controlling and coercive behaviour, with subheadings of the varieties of behaviour that are alleged, which can encapsulate what you then need to prove, I think will become commonplace. But as to the bold question, can the magistrates now force you to limit yourself to 3 things on one piece of paper? I don't think they can. I think those days are now over. Be robust, tricky though it may be at times. So thank you very much, everybody. If anybody has other follow-up questions, email us or be in touch through Sean. We'll be more than happy to chat. Make contact with one of us directly. You're very welcome to do so. And we hope that we will see you again. Listen to the podcast. It's good. It's great, actually. At least those ones that are done by my colleagues are. So we commend that to you, and we'll say goodbye. Jen, is there anything else that you would like to add?
No, thank you, everybody. Appreciate you giving up your Friday lunchtime to listen to us.
Absolutely. And we'll bring it to a close. Thank you very much indeed all.